just.
Okay. Okay.
All right, we're on the record. Record will show the presence of the defendant and all counsel. Court has received a motion to preclude the testimony of Dr. Janeen DeMarte for failure to timely disclose report. It was filed yesterday. I've read the motion. Does the state have a response?
We do. The report by Dr. DeMarte was disclosed, I think, 2-3 years ago. I do note that Geffner did not prepare a report. It was never disclosed, neither did Fonseca. But we have disclosed the report. I think more properly what they're talking about is a number of handwritten items prepared as a result of a conversation with Chris, Guy Hughes, and Lisa Diadone. The motion indicates that, I read this morning, or just now, says that Dr. DeMarte did not disclose any handwritten notes at all. There aren't any handwritten notes to disclose. The number of notes that they complain about, or the pages of notes that they complain about, is 14 pages. And these pages were disclosed this past Friday during the interview, and they questioned her about the content of those notes. And again, those were interviews with Chris and Sky Hughes. The items covered in those notes are reflective of Chris and Sky Hughes' statements to CBS 48 Hours that have already been disclosed to the defendant. So there is nothing in there that is new to them. Additionally, even if somebody was the slowest reader ever, they would have plenty of time to read them and prepare appropriately. They also note that they were created prior to defense expert Geffner finishing his testimony. As you will recall, the state did not question Geffner with regard to anything having to do with Chris and Sky Hughes. I would note that as Dr. DeMarte indicated to defense counsel, those notes were not disclosed or given to the state to disclose until the date of the interview. Those were given to me at the same time. I did not use, they were not created in time to use them with regard to Fonseca, and I didn't use them. They weren't turned over to me, and so I didn't use them when it came to Geffner. So the bottom line with all of this is that the state sees no prejudice with regard to the timely disclosure of these summaries of her interviews with telephonic interviews with Chris and Sky Hughes. They're not notes, they're summaries of the interview that she conducted of Chris and Sky Hughes, as well as Lisa Diadone. So there is no prejudice, specifically and especially because they weren't used by the state to question Geffner, nor were they used to question Fonseca. And so this complaint that they were available at the time that Geffner was testifying, they didn't have them, the prosecutor didn't have them at that time, and in fact did not use them in cross-examining Mr. Geffner.
So, Mr. Martinez, you were not aware that Dr. DeMarte had these notes until Friday, is that correct?
I wasn't. I did know that she had talked with them.
But you didn't know she had made notes? All right, and I do not have a copy of the notes at issue. Did you want to provide the court with a copy of those notes, Ms. Wilmot?
I could do so, Judge. I don't have a copy with me, but I can provide the court if that's important for the court to review.
Well, I thought you might want the court to retain them for the record.
Sure, we can certainly do that, Judge.
All right, go ahead.
I would frame the issue quite differently than the state does. The issue is that Dr. Geffner's notes and Dr. Fonseca's notes were disclosed to the state in July of 2014. Since that disclosure, we have continually asked the state for the complete set of notes from Dr. DeMarte. We were continually told Dr. DeMarte hasn't completed any. We did receive some notes in December, But the issue in this situation, Judge, is that we didn't even get to interview her until January 30th, which was last Friday. And even before that interview, we were not told that there was any additional notes. So it wasn't until the middle of the interview that we find out that Dr. DeMarte actually created 14 pages of single-spaced typewritten notes based on her interviews. Those interviews were conducted on December 15th and December 24th. Both were conducted before Dr. Geffner finished and before the defense rested. But the problem is that the state never advised defense that these notes existed. I understand that Mr. Martinez is claiming to not be aware that the notes existed. However, Dr. DeMarte's notes also reflect the fact that they have spent over 12 and a half hours together consulting about this case from December 7th through January 29th. So in that time, and Mr. Martinez admitted that he knew that these interviews were completed. So to know that these interviews are completed and to fail to even ask or inquire of his own expert if notes were created doesn't absolve the state from failing to disclose these notes. They were disclosed, copies were given to just one of us during the interview, so only one of us were able to look at them at the time. 14 pages of single-spaced notes compromised the interview as well, because although some questions were asked, we weren't able to review them all in detail and then ask Dr. DeMarte questions about them. Further, we weren't able to discuss it with our experts about what some of these things that these witnesses are claiming, how they affect what our expert would have said, or how our expert might have used them in their testimony. And now it's strategically disclosed to us after the defense has rested. That there can be no other reason for that other than strategic purposes to not disclose it. Mr. Nermi asked Dr. DeMarte during the interview why these notes weren't disclosed prior to this, when she was well aware that this court had ordered her to turn her notes over by October 16th. And her response was, well, I knew that you would ask for them, but I'd see you at the interview. I mean, her response was not at all a reasonable reason to fail to provide these new notes. And I understand that the state also claims that these interviews are reflective of similar information that were contained in the CBS interviews. We would dispute that, Judge, and that's something that ultimately makes no sense, because if that were true, there would be no need for Dr. DeMarte to go back and interview these people if it's the same information as what was contained in the CBS interviews from 2008. So basically, we're left with all of these new notes, all of this information that we were not able to conduct a proper interview about. Furthermore, some of the comments in these notes, at least on our review thus far, are noting things that are concerning to the defense, that Dr. DeMarte might try to make a comparison between life versus life. In other words, to compare Mr. Alexander's life to Miss Arias' life, which is completely inappropriate under Pendelly. There are comments that the Hugheses have called Mr. Alexander a savior. That would be completely inappropriate to put before the jury, as it's comparing a life versus a life, and that's inappropriate. The issues, Judge, is that given this information and when it was disclosed, it's untimely disclosure, and not just untimely, but the fact that it was disclosed after the defense rested, even though this court had ordered the state to turn over all notes by October 16th. That speaks to strategic reasons, and we'd ask the state to be precluded from having Dr. DeMarte testify to anything with regard to those interviews.
All right. I am at somewhat of a disadvantage since I don't have the notes to review. However, I will take the state at its word that it had no knowledge of these notes until Friday, and that these notes were disclosed to the defense immediately upon the state learning of their existence. I am also aware that the defense has previously indicated their intent to recall both of their experts at a later stage in this proceeding. Under Rule 15.7, the sanctions portion of the disclosure rules, it provides that the court shall consider the failure to comply, whether or not the materials could have been disclosed earlier, even with due diligence, and whether the information was disclosed immediately upon its discovery. All orders imposing sanctions shall take into account the significance of the information not timely disclosed, the impact of the sanction on the party and the victim, and the stages of the proceeding at which the disclosure is ultimately made. After considering all of these factors, the court finds that preclusion of the witness is not an appropriate sanction, especially in light of the fact that the state is indicating that the materials in these notes were provided previously to the defense through other means, and the fact that the notes were disclosed. I do believe it is appropriate, in light of the late disclosure, without finding fault, that the defense should have an opportunity to further interview Dr. DeMarte relating to the contents of the notes of the interview with Mr. and Mrs. Hughes and Ms. Desdon. I believe that that interview can occur after Dr. DeMarte has started her testimony, so I'm not prepared to delay the beginning of her testimony today. But certainly before cross-examination begins, I believe the defense should have an opportunity to fully interview Dr. DeMarte regarding these notes. So that is my order. There are a couple of other matters that I want to take up with counsel. Yesterday we had some exhibits marked and then redacted exhibits were admitted. We're going to keep the original exhibit unredacted for purposes of appeal. So if there's any objection to that, you need to let us know. I know that the defense also took an original and you're going to provide a redacted copy today for the court to admit. Has that been done?
Your Honor, our understanding was that the court wanted the exhibit that was marked redacted. That has been redacted. I haven't had a chance to double check it, but I will bring a clean copy. I spoke to your clerk. I will bring a clean, unredacted copy tomorrow.
All right, and then I want the state to have an opportunity to look at it to see if there were any other issues. Court has not ruled on the relevancy objection, and I did note yesterday that there may be some portions of that transcript that are not relevant. Okay. With regard to the motion to preclude the testimony of Mesa PD Detective Smith, I'm not going to take that up today because the jury is waiting, so we'll take that up at a later time, either today or tomorrow.
And Judge, I guess just for timeliness, we would just request under Rule 15.1 that we be provided with his report as soon as it's completed, just so that request is out there.
Mr. Martinez?
He will, but as he explained in the interview, he is the individual that if issues come up during the trial, receives a phone call, and he is asked to investigate. As he indicated, he won't have a report until this is done because of the nature of the proceedings. So what he told defense counsel, he said, I have the hard drive, the 09 hard drive to look at. He did provide a timeline for the 09 incident and then also provided the screenshots for the discrepancy in the time between 10 and 11. He's done all of that. There isn't anything else for him to disclose. He can disclose a copy of the 09 hard drive, but to be fair to them, they're going to come back and say, well, it doesn't have anything on it. And it will, and it won't. But if you want me to, I will ask him to disclose everything that he's got sitting there of his work in progress. If that's what you want, I can do that.
And Judge, Detective Smith has told us now twice in 2 separate interviews that he's been working on a report. He was very specific in his last interview with us on Thursday, but January 29th, that he has been working on a report. He should complete it in a week or 2. That's what he told us word for word. So that's what we are requesting, his report. And if the state is telling Detective Smith not to complete it before he testifies, then that's something we can discuss on the motion to preclude.
I'm not telling him anything. That's what he says.
Mr. Martinez, I assume that Detective Smith is diligently working on the report. It's just a time-consuming process. Is that the reason there's been this delay?
This is my impression. My impression is that he works on it when he gets questions from us. So I can't stand up here and say to the court that he's working on it. He says that these issues that I ask him to look into do take time, but he has other cases, and as soon as he puts my questions pretty much a priority so that he can provide answers. But he hasn't provided anything to me in writing. What he does is I pick up the telephone and ask him, what is the answer to the question? And then he says, well, give me extra time, or here's the answer to your question. For example, the teensex.com, I asked him to look that up to see whether or not it was put there by somebody using fingers or whether or not it was done by a program. He called Detective Flores or left a message. I don't know which of the two it was, but this is just by way of example. And he said, no, I checked it out, and it was placed there by a computer program. So what he did is he went in and he looked at it, and then he gave us the information. So it's not like he's sitting down and writing something down like Detective Brown. He looks things up. And so I'm willing to ask him to disclose everything he has there so that they can see that what he's done, which is just look at things. But that's going to seem like I'm trying to avoid the discovery obligation.
Was the defense expert present at Detective Smith's interview?
He was.
Yes, Judge, he was. However, Detective Smith was unable to answer numerous number of questions that we posed to him because he chose not to bring his computer to the interview, so he couldn't look things up there, and because his report was not completed. But I think it's best just to take the witness's word for it, which is he has been working on this report. He should have it completed in a week or two. That's exactly what he told us. So if that's the case, Judge, then we are entitled to what he's worked on and what he completes.
Mr. Martinez, I would like you to contact Detective Smith at the noon recess and find out the status of the report, if he is preparing one, and if not, what materials he does have that he could provide.
I will contact him.
Make a record of that after lunch.
At the noon hour.
Right, thank you. One other matter I wanted to put on the record, since Miss Arias chose not to complete her testimony and the state did not move to strike her testimony, I do have 3 juror questions, and I wanted to give the parties an opportunity to review these 3 questions. They're marked 15, 16, and 17. So if at any point you want to look at these questions, I think now would be an appropriate time for you to do so. And the clerk will have those if you want to look at those at the break. All right. Yes. Hold on. All right, and the final issue before we bring in the jury is there was a request for the transcript of the in-chambers proceeding on October 30, 2014. We took this up a couple of weeks ago. I believe defense counsel wanted an opportunity to review the transcript before objecting to its release. I don't have anything in writing. So does the state have any objection to releasing the transcript?
No.
Does the defense have any objection at this time?
We do, Your Honor. The reasons behind motivated Miss Arias' decision regarding her desire to testify in a sealed proceedings, I think she did that under the guise and the discussion in that regard, under the guise that this was sealed, and she was relying on the court sealing these proceedings. To unseal them now, I think, would be to her disadvantage in terms of the sort of motivation, the things that motivated her to have them sealed to begin with, concerns for her safety, concerns of the safety of her family. So we believe that they should remain sealed.
So your objection is to her stated reasons for wanting her testimony sealed, correct?
Yes.
And the rest of the transcript, you have no objection?
To my recollection, that was the entirety of the dialogue.
Well, I'm going to ask you to look at it today during the noon hour and let me know if there are any other objections, and then I will rule based upon any other objections that you make.
Okay.
All right. So it will be here. The clerk will have it for you to review. All right. Let's bring in the jury.
Just before we do that,
Yes.
may we approach with regard to the in-chambers matter yesterday?
Yes.
All rise for the jury.
Please be seated. The record will show the presence of the jury, the defendant, and counsel. The state may call its next witness.
Case called Janeen, DeMarte.
You do solemnly swear that the testimony you're about to get will be the truth, the whole truth, and nothing but the truth, to help you God.
Please have a seat.
May I have your name?
Janeen DeMarte.
Go ahead and pull up the microphone. What do you do for a living?
I'm a clinical psychologist.
Pull it a little bit closer.
Closer.
And how long have you been a clinical psychologist?
I was licensed in 2010.
And clinical, is that a term of art? Does that mean something as opposed to any other kind of psychologist?
Sure, so there's several different branches of psychology, clinical being one. It's a study of psychopathology, mental illness, psychological disorders. It's related to the treatment and evaluation of such disorders.
And how long have you been licensed as a psychologist?
2010.
And are you licensed in the state of Arizona?
Yes.
Where did you attend school to get your doctorate?
Michigan State University.
What years did you attend?
I completed my master's degree there in 2005 in clinical psychology and then completed my doctorate degree in 2009.
If you don't mind pulling the microphone just a little bit closer. And anything about did you say Michigan State?
Yes.
Anything about the program at Michigan State that you focused on or that interested you and that's why you went there?
I originally chose to go to Michigan State, chose to apply there because there were researchers there that I was interested in the research that they were doing.
And what kind of areas were they researching that?
Violence and domestic violence.
And when you got there, did you learn or study under their tutelage?
Yeah, so the way that it works is in these PhD programs, you go to work with specific researchers. And so as part of that, I worked in their research lab that was focused on mothers and infants who were exposed to domestic violence.
And how many years did you actually study this particular area there at Michigan State?
I was only in that research lab for 1.5 years.
And how long is the program?
The program is 5 years plus a residency afterwards.
Why switch over after a year and a half?
They brought in another researcher who focused on broader areas of violence, specifically related to antisocial behaviors, which is essentially criminality. That's a short explanation of it. And I had an interest in doing that more.
When you say antisocial behaviors, and that it relates to criminality, can you explain that a little bit further for me?
Sure. So antisocial doesn't mean what people typically use it as is somebody who isn't interested in being part of society. What antisocial means is it's a term that says that someone breaches societal norms, engages in criminal behavior. So essentially the research lab that I was involved in looked at the genetic aspects and the behavioral aspects that are associated with such behavior.
Even though you looked at those aspects, clinical to me means that you do face-to-face conversations with people. Did you do that there also or not?
Yes.
Do any interviews with these people?
Yes.
And what percentage, or describe that experience for me?
Are you talking about specifically related to the research?
Yes.
So as part of that first study that I talked about being involved in, we'd go to people's houses, research participants' houses, and we would evaluate the mothers and the children that had been exposed to domestic violence.
How about in the second portion of the study?
The second researcher?
Changeover, right?
So that one was much more elaborate because it wasn't just one. The first lab that I was in was a longitudinal study, meaning that we had followed the families over time. So it was one big study. When I moved over to the other research lab, I think there was 5 or 6 different studies that we were running at a time, many of which I interacted with children and adults.
And what year did you say that you graduated from Michigan State?
I graduated in 2009, technically.
When you say technically, that implies that there's an explanation. Tell me.
Well, I left Michigan State University in 2008 to then go complete my residency, also called an internship, here in Arizona at Arizona State Hospital. And it's not until I'm done with that residency that I'm able to formally graduate.
So from 2008 to 2009 is when you engaged in this residency.
Yes.
You said it was at the Arizona State Hospital?
Yes.
What kind of cases or areas were you exposed to during that residency at the Arizona State Hospital for that year?
The state hospital has 3 primary branches to it. One branch is what's called the forensic branch. These are individuals who have committed a violent crime and have been deemed guilty except insane at the time of the crime, or they're there for the reasons of competency to see if they can be restored to competency so as to engage in a trial. In addition to the forensic realm, there's a hospital there called the civil hospital. These are for individuals who have pretty severe psychological disorders that have been in and out of hospitals, and this is more of a long-term placement for these individuals. The third area at the state hospital focused on individuals who are deemed sexually violent persons. The short of it is these are individuals who have engaged in some sort of sexual crime, have been incarcerated, and because of their level of danger, upon release, they were evaluated by a psychologist, and if they were deemed risky enough, they were then placed in Arizona State Hospital to be housed for the purposes of treatment.
With regard to the work that you did with the SVPs, or sexually violent predators, specifically, what type of tasks did you undertake with regard to them during your internship?
The work that I did there was purely therapeutic. I did not complete any psychological evaluations there. What I did is conducted individual therapy and group therapy.
And when you say therapy, exactly what is it that you did?
I did psychological analysis of them, helped them understand and gain insight into their behaviors, their emotional state, helped them understand their motivations of why they engaged in their criminal behavior, and help them better understand their backgrounds.
So after completing the internship in 2009, is that when you obtained your PhD?
I did.
And then did you just apply to the state, or do you have to take an exam, or how does it work in order to be licensed in the state?
Technically, in the state of Arizona, which is different from other states, you can immediately become licensed if you have enough hours to do so, hours-based pre-doctoral hours.
When you say pre-doctoral hours, are we talking about the internship, or are we talking about the study that you undertook back at Michigan State?
I believe that they combine hours from Michigan State University in addition to the internship hours. I'm not sure off the top of my head.
But did you have enough hours to become licensed in 2009?
I did.
And did you choose to become licensed then?
No, I chose not to become licensed.
Why not?
There was a couple of reasons. One reason is that I wanted to continue to have the opportunity to directly work with other psychologists and work under their license so that I could continue to learn and grow and hone in on the skills that I had already developed. The other reason is because, like I said earlier, not every state has the same policy. Many states require that once somebody graduates that they do what's called postdoctoral work, which is continually working in the field for either 1 to 2 years, depending on the state. Most states require 1 year before licensure. So I wanted to ensure that if I wanted to leave Arizona and not live here anymore, that I would be able to practice elsewhere.
So because of the extra work that you did between 2009 and 2010, you can you can actually go to other states.
Yes, I have enough hours for most states. Yes.
And what did you do between 2009 and 2010 in terms of your education and training during that period of time?
I worked at a few different outpatient clinics.
Which ones did you start with? The first one, where did you work at?
I worked at an outpatient clinic where I conducted disability evaluations.
What else? Where else?
I also worked at a different outpatient facility where I conducted what are called psychosexual evaluations. This is where I evaluated, they were actually adolescent males who had engaged in a sexual crime, and I was asked to evaluate them from a psychological perspective. In addition to that, we did evaluations for CPS.
And after that,
services.
where did you go after your year?
After what?
Your year, that year that you were
So
conducting or trying to get these hours so that you could move to another state if you wanted to.
So
What did you do after that?
the third place, before I moved on, the third place was another large behavioral health agency where I conducted psychological evaluations and therapy.
What was the name of that one?
Bayless Behavioral Health.
And after you'd completed your hours, did you then become licensed? Did you continue working for Bayless?
Yes, when I became licensed, I continued at Bayless.
And what was your position at Bayless?
When I started there, I was a postdoctoral fellow there, and then once I became licensed, I became the clinical director of the agency.
As a clinical director, what were your duties?
I had complete oversight over the entire clinic, and this was actually quite a large clinic. We saw children as young as 3, and I think our oldest patient was in their 90s. So what I did is I oversaw all the providers that were there, whether it be master's level counselors, doctoral level psychologists, psychiatrists, nurse practitioners. I oversaw the practices.
And you did that for how long?
I was there for 2.5 years doing that.
When did you leave the Bayless business?
I left in 2012.
And what are you doing from 2012 to the present?
I've been in private practice.
And in your private practice, do you handle cases that are called forensic cases? Do you do that?
I do as part of the practice.
And a forensic case involves coming to court in criminal cases, right?
Not always criminal and not always coming to court, so it certainly could involve testimony. The vast majority don't involve testimony. I also do civil cases where there's not a crime, and then I do criminal cases.
And during that time, have you worked for both the state as well as the other side?
Yes.
And presently, how many cases do you have that are in the forensic arena?
I have 7 open cases.
And of those 7 open cases, how many of those were you retained by the state?
I have, including this one, 3.
And tell me about the other 4 that are left over.
I have 3 civil cases, 2 where I was hired by the defense and 1 by the plaintiff. And then I have another case where I was hired by the probation department in Pinal County.
And prior to these cases, had you previously, in the other cases that are closed, were you hired by the defense as to those cases?
Yes.
In any of those cases?
Yes.
During the time that you had practiced, how many times have you testified in court involving a criminal case?
5 times, including this one.
And how many of those cases involved the charge of murder?
4.
And ma'am, in all of those cases that you've testified, or including all of the cases that you've testified, has any judge in writing ever called you a hired gun?
No.
In any of those cases that you have testified, not testified, in any of those other cases that you had, and you've submitted anything in writing, has a judge ever indicated that whatever you submitted lacked credibility?
Objection, vouching.
Overruled, 2 minutes.
No.
And in some of those cases, have you agreed with the expert on the other side?
Yes.
In some of those cases, have you disagreed with the experts on the other side?
Yes.
In those cases where you disagreed with the expert on the other side, have you ever referred them to the licensing agency here in the state of Arizona for unethical conduct?
No.
In this particular case, when did you begin your involvement in the Jodi Arias case?
My first evaluation of her was in July of 2011.
And the purpose, why were you retained? What is it that you were going to do back in 2011?
I was asked to conduct a psychological evaluation to help determine the presence of a psychological disorder.
And at that time, did you already have 2 so-called evaluations or medical reports that were available to you to review?
Yes.
And one of those reports was from a female psychologist, correct?
Yes.
And the other report was from an individual by the name of Richard Samuels, correct?
Yes.
What did you do in this particular case? You indicated that you visited the defendant. That's called a clinical interview, right?
Yes.
What did you do in this case besides that?
So as part of a forensic psychological evaluation, there's a few different things that we do. The first is the clinical interview, like you just mentioned, where I essentially talk to the person and ask them a variety of questions about their background, including medical history, psychological history, family history. In addition to that, I conduct psychological evaluations, psychological tests. Some of these tests are handwritten paper and pencil kinds of tests where I give it to the person and they fill it out themselves, and others are administered to the person. In addition to that, I review records, and in this case, a lot of records. So what I do with all that information, one other aspect I forgot to mention is that I watch the person. I use what are called behavioral observations. I'm sitting in the room with the person I'm evaluating, and I watch the way that they respond to questions. I watch how they are emotionally, and all of those different areas I use to integrate together to make sense of the information. So I wouldn't take one piece of information and make a conclusion based on that. I would get all of it and put it together.
And how many times did you sit and speak with the defendant and have a clinical interview? How many occasions?
Well, I met with her on 4 different occasions.
For a total of how many hours?
Roughly about 17 hours.
And this was beginning what month and year again?
July of 2011.
And during that time, you also mentioned that you also conducted some psychological testing, right?
Yes.
And what kind of tests did you administer to the defendant?
I administered one very brief reading test just to make sure that she has the capabilities of reading the self-report measures by herself. And remember, those are the measures that I would hand to her. She'd have to read it herself. There's a certain reading level that's required for that.
Well, let me ask you, why give her a reading test in this particular case? Why do that?
I just wanted to make sure that she reached that threshold. It was a very, very brief test.
Does it give you a score, or what does that test do? In other words, how do you administer it? It sounds like it's a very brief test, but what are we talking about?
It's a laminated sheet of paper that I have that has a list of words on there, and I simply just asked her to read the words to me. And based on that, I was able to identify how many she got correct, and I was able to come up with a grade equivalent to the number that she got correct.
And it sounds very basic, but what grade equivalent did you get from that?
She got the highest, which it goes up to 12.9, so it was 12.9 or above.
Okay. Then what did you do? What other tests did you administer?
I administered what's called the WACE, it's the Wechsler intelligence scale, essentially evaluates her intellectual abilities.
And that test, how long does it take?
I would say about an hour to an hour and a half.
And on that particular test, what were the results? Did you get, for example, the verbal portion and what did you get? What were the results of that?
The results suggested that Miss Arias had high intelligence, that she was in the high average, and that there was no concerns intellectually.
And was there a number associated with that or not?
Of her overall intelligence, yes.
What is the number what is the score that you got on that?
I'd have to refer to my notes for that.
Go ahead and do that.
Objection as to relevance.
Approach, please.
Do you have those notes in front of you?
I do.
And in terms of the notes that you're referring to, is that the actual test itself?
The test results, yes.
Okay. And this has those issues about, does it include the questions and the answers and all that?
This one does not, well, one portion has the questions, the rest of it doesn't.
Go ahead and give me the portion, or is it just one packet? Or is it two?
I can separate it.
If you could give me the one that has the score on it, please.
Just a summary of scores?
Yes.
Your Honor, if the doctor's going to be referring to any of the other notes she's left on the desk, I would ask those to be marked as well.
I'll put them down.
All right, as we get to them, if she's going to use them.
Take a look at Exhibit 863. Is that these scores on the wave?
Yes.
That's also known as an IQ test, correct?
Yes.
Are those true and accurate? Are those the true and accurate scores from her completing the WACE test?
Yes.
I move for the admission of Exhibit 863.
May we approach?
Yes.
And this score report, you disclosed it to the female psychologist and Mr. Samuels, correct?
Yes.
And with regard to this, that was used part and parcel of your evaluation of the defendant to reach whatever opinion you reached, correct?
Yes.
Yes, I move in 863.
Anything else from the defense?
No, just the objections already noted.
863 is admitted.
What are we looking at here when we say that we look at verbal comprehension? What are we looking at there? What is that test? What is that testing?
To provide context around this, there's 4 different areas of intelligence that's conceptualized into the idea of intelligence, and the first 4 that are listed there, including verbal comprehension, are what are called an index score, so it's one area of intelligence.
That's the first 4. And on verbal comprehension, what did she score?
Her score is 136. You look at the composite score.
And we have something here very superior. What does that mean?
It's very high. This is the qualitative description is on a continuum of being very low, which is called borderline intelligence, all the way up until very superior.
And the perceptual reasoning, what are we talking about there?
Being able to manipulate information, objects in space. So a good example of that would be like puzzles.
And her score on that one was what?
It was 113.
Then we have the working memory and the processing speed. What is working memory?
Memory is the ability to take in multiple pieces of information and utilize it at one time.
And processing speed?
Processing speed is essentially the speed at which information is processed, how fast something's processed.
And we have her scores there, and it indicates that it's average. This rating, if you will, superior, high average, or average, is that something that you came up with, or is that something that is from a booklet from the Ways people? How do we arrive at this description?
This is not something that I came up with. This is part of the testing protocol where I administered the test to her, scored it up, and then inputted it into a computer, which then gives me this output.
And the full scale, what are we looking at here? Is that, I know this is number 5, so is that the same as verbal comprehension, or is that something different part of it, or what are we looking at there?
Objection, compound question.
Sustained.
What are we looking at there?
Full scale is the combination of the first four index scores.
And her score is what on this one?
It's 119.
And then the general ability, what is that about?
We just use that in cases where processing speed and working memory is significantly different. We would take it out. So essentially when there's a spread in the scores, sometimes some psychologists prefer to just look at the first 2, which is verbal comprehension and perceptual reasoning. So that just factors it out.
And so what is her score overall?
So we would consider that the full scale, which
What
is
was that?
full scale IQ, which is 119, which would be the high average.
This one right here.
Yes.
So you administered the Ways 4. What else did you administer?
I administered a test called the Trauma Symptom Inventory.
And does it have a number after it? 1, 2, 3, 4, or not?
The edition of it was the first edition.
Okay. And is there now a second edition of the Trauma Symptom Inventory?
There is.
And what date did you administer the Trauma Symptom Inventory?
I'm not sure. It was one of the dates that I saw, or it was likely in August, one of the 3 dates in August.
And when you administered it, is it written on the test or not?
Yes.
If you could pull that out for me.
Administered on August 12th.
Your Honor, I'm again going to ask that her notes be marked. She's referring to that whole stack of notes in her hand.
Yes.
Give me the one that has the date on it.
They all have the date on it. You could.
This one.
Your Honor, I'm asking that they all be marked.
If you can do that during cross.
Right. Overruled.
Your Honor, may we approach?
You may.
And take a look at Exhibit 864, does that refresh your recollection as to the date that TSI was administered?
Yes.
What date did you administer the TSI?
August 12th, 2011.
You're going to have to pull that closer because you're
August 12th, 2011.
And you indicated that there was a TSI-2, correct?
Yes.
The TSI-2, when you administered this, how long had it been out or published?
It was about 3 or 4 months.
And this TSI-1 that you have there, what is the purpose of it? What is it that measures?
It's a self-report measure that identifies exposure to traumas, to no specific trauma, just a trauma response. So anxiety, avoidance, negative emotional states.
And you said it's self-report. What does that mean?
It means that it's a paper and pencil questionnaire that I handed to her and she filled it out on her own.
So for example, there are questions and then there are answers that she fills out, right?
Correct.
Are you familiar with something called the PDS?
Yes.
Is that the same kind of test?
Yes.
Let me show you exhibit number 540.
Relevance, Your Honor. It's improper rebuttal.
Approach, please.
You're familiar with exhibit 540, correct? And was this part of something that was turned over to you by somebody by the name of Richard Samuels?
He didn't hand this over to me. I received.
Pardon?
He didn't hand this over to me. He handed a bubble sheet related to the PDS.
And these are the questions that are on 540 are those the questions associated with the bubble sheet?
That looks like it, yes.
And with regard to this particular test, in forming your opinion, this is something that you looked at, isn't it?
Yes.
And with regard to this, there is a part 1. Do you see that?
Yes.
Let's see. And then it has some questions there. 3 and 4, do you see them?
Yes.
And you're familiar with those, right?
Yes.
And then you see the answer, or you see part 2, and you're familiar with the answer that the defendant provided to question number 14, right?
Yes.
And which answer did she provide?
I think it was number 4.
Which is non-sexual assault by a stranger, correct?
Yes.
Are there any validity scales attached to this?
No.
One of the things that Dr. Geffner told us on his, he testified, was that yes, he looked at this and he realized that the answer number 4 was not truthful, but then he said, but the remaining answers, according to the defendant, were truthful.
Objection, Ms. State's testimony.
Overruled. The jury is directed to recall the testimony of Dr. Geffner. You may continue.
With regard to the remaining answers, what is your view about the validity of the answers of the rest of this test, given the fact that the answer to number 14 is clearly not truthful?
The way that this test is set up is that they identify a number of different traumas, as you see here, and number 14 asks if they've identified more than one trauma to identify the one trauma that's most bothersome. The subsequent questions are related to that trauma in particular. So to answer your question, because number 14 was not accurate and not based on truth, I would not use the rest of the test. It's completely invalid.
Does the TSI that we've been talking about, does that have any validity scales?
It does.
And in that particular case, is it something that, what is the purpose of the TSI? Is it to diagnose something or not, or what is exactly what the TSI does?
Objection, compound question.
Sustained.
What does the TSI do?
The TSI identifies emotional symptoms as a result of someone being exposed to trauma.
And how is that different from exhibit number 540? Are they the same or are they different?
No, it's very different. The PDS is designed to map more cleanly onto the diagnosis of post-traumatic stress disorder, because what it does is it asks questions that are specific to the actual diagnosis. There's certain symptoms that we look for, and it maps much more cleanly onto that. The TSI asks for a broad range of symptoms that's not specific to PTSD, but just captures when someone has been exposed to a negative experience, something that they experienced traumatic in their life. It's more general.
We heard from Dr. Geffner that he administered something called the DAPS. Are you familiar with that?
Yes.
Is the DAPS something that is similar or looks for the same sort of areas as exhibit number 540?
Yes, the DAPS is much more similar to the PDS.
This exhibit number 540, you indicated that PDS does not have validity scales, is what you told us, right?
That's correct.
Does the DAPS have any validity scales?
It does.
When you say, I say scales, how many does it have?
There are 2, I believe.
And so, to get back to the TSI, isn't it looking for the same thing when you say trauma? Isn't that what PDS and DAPS are looking at? How is it different?
Objection, compound question.
Sustained.
How is it different? How is the TSI different from the PDS?
Objection, asked and answered.
Overruled.
How is the TSI different from the PDS?
Right.
So that the PDS maps on directly to PTSD symptoms, whereas the TSI is much more broad.
But they both talk about traumas, don't they?
They talk about a trauma response, yes. And the PDS focuses on what is that exact trauma, whereas the TSI does not identify what the trauma is.
So as I understand it, for example, the DAPS focuses on one specific trauma, whereas the TSI focuses on many.
Objection, leading.
Overruled. You may answer.
The DAPS is very similar to the PDS in that it identifies here are a number of traumas that you could be exposed to, which one were you exposed to, and which one stands out to you the most, which is the most troublesome. Whereas the TSI doesn't at all touch on any kind of etiology, meaning where did this come from, what trauma might this come from. It didn't touch on it at all.
You were talking to us about the TSI, and how long does it take to administer that particular test? Is it a long test, short test?
It's about 100 questions, so not too long.
And are there any numerical results with that, or what's the utility of the TSI?
It tells me whether she's experiencing any kind of negative emotional response in general, whether it be related to depressive symptoms, anxiety. There's scales that are related to sexual concerns, intrusive experiences.
And can you give us an opinion as to what she reported, or is that something that's given as a general, or is included in your specific opinion?
Objection, compound question.
Overruled. You may answer.
What I could say is that this is certainly information that I used as a point in coming up with a conclusion. In terms of what my findings were, was that she did endorse a number of symptoms across the different scales that were evaluated related to experiencing a lot of anxiety, experiencing some depressed mood, some sexual concerns. There was several different endorsements.
In terms of the depressive component, does that tell us where it comes from, or is that something that it just tells you that?
Objection, compound question.
Sustained.
Well, the depressive mood, does it tell you the etiology?
It does not talk about the etiology,
And etiology means what?
where it came from, the cause.
What other tests did you administer?
I administered a test called the MMPI-2.
And the MMPI-2 is what?
It's actually the most commonly used psychological test in forensic cases. What it does is it identifies the presence of personality traits and general psychopathology, meaning psychological disorders, symptoms of.
And what were the results after you administered it? What did you find with regard to that?
The first thing that I always look at when I look at the MMPI is I want to know what the test taker's approach is to the test, meaning did they seem like they understood the questions? Was there an indication that the person was not being truthful in the test by exaggerating or maybe minimizing? So the results related to that was that Miss Arias did not appear to inflate her answers or minimize them in any kind of way. So because of that, I was able to use the test, use the results from the test.
It sounds like you're talking about some validity scales, are you?
Yes, those are validity scales.
How many validity scales are there?
I believe there's somewhere about 9. I'd have to reference my notes.
Any other tests that you administered other than the MMPI? You talked about the TSI, the MMPI, the WAIS, initial one. Any other tests?
The rat, no.
And so you administered these tests, and you talked to the defendant about it. Is that when you reach an opinion, or how does it look?
No, so I review the records.
Right.
I take into account, and as part of those records, I take into account the psychological evaluations that were done previously. I put all this information together, so my interview, the tests, my behavioral observations, and the notes that I reviewed, which included many interviews with different people, and then I came to a conclusion.
And that conclusion, was it in a report?
Yes.
And what was your conclusion as to the defendant?
My conclusion is that she has a personality disorder called borderline personality disorder, and that she also has what's called an adjustment disorder with mixed anxiety and depressed mood.
When you're talking about an adjustment disorder, what are we talking about? What is that?
An adjustment disorder is the presence of psychological symptoms, in this case specifically related to anxiety and depressed mood, as a result of a change in somebody's life.
And this adjustment disorder, if you could explain it to me again.
Sure. The presence.
Objection, ask and answer.
The presence of negative psychological symptoms as a result of some sort of change or adjustment in someone's life. Essentially, this is for somebody who would have difficulty adjusting to potentially a new environment.
So, for example, this adjustment disorder, could it be an individual who goes from outside world, if you will, to being jailed?
Objection calls for speculation.
Overruled.
Yes, that would be an example of where someone could experience some psychological problems as a result of that.
How about another example? Could it be that if it's a person who goes from, for example, one school to another school, they also have this adjustment disorder?
Yes, it's possible.
How about if an individual has, for example, a medical condition that comes up? Could there be this adjustment disorder present?
Yes.
And one of the things, what labels can be placed on this adjustment disorder? Could that be called a mental illness?
Objection, compound question.
Sustained.
You call that a mental illness?
It can be called a mental illness. I prefer to use the word psychological disorder.
And when we were talking when we had an interview, did you use both of those words interchangeably when talking about the defendant's diagnosis?
Yes, more so psychological disorder though, but yes, they can be used interchangeably.
So how about borderline personality disorder? What was the term that you preferred?
Well, it's a personality disorder under the auspice of a psychological disorder.
So is it the umbrella that's the psychological disorder?
Yes.
And is the umbrella also the umbrella for the adjustment disorder? Right.
Yes.
And you have used the word mental illness with regard to the borderline personality disorder, right?
Have I used it before?
Right.
Yes.
During the interview.
Yes.
How about with the adjustment disorder? You used that as a mental illness.
Yes.
So, for example, if a person, with the examples that you've given me, if a person goes from one school to the other and they have this adjustment disorder, that can be called a mental illness.
Yes, while they have the symptoms.
take a look at exhibit number. You received some what's called notes or raw data from somebody named Robert Kepner, correct?
Yes.
And specifically, did you receive some items involving the DAPs?
Yes.
When did you receive them? Generally, the month and the year.
I'm not exactly sure when I received them.
Was it 2 years ago?
Objection leading.
Overruled. You may answer.
It was more recent. It maybe sometime around October.
Objection
2014.
speculation.
I'm not sure the exact date.
Non-responsive.
Overruled. The answer will stand.
And then, after you received one set of DAPs answer sheets, did you receive another?
Yes.
And what date did you receive those?
Again, I'd have to refer to my notes. I think it was,
Well, let's do this. Take a look at exhibit 839 and see if that refreshes your recollection when you received the second set.
yes,
Okay? So when did you receive the second set?
December 23rd, 2014.
And this is what I actually showed you. What was it?
That was a letter from Dr. Gaffner.
And in it, he talks to you about what you should be aware of in terms of this data, doesn't he?
Yes.
He talks to you about what should you be aware of.
He talks to me about what I should be aware of not releasing the data.
He talks to you about confidentiality.
Yes.
Is that something that you covered in school?
Yes?
Is it something that you think you need him to school you on?
No.
Is it something that when you've released your raw data to anybody, do you also admonish them about the confidentiality?
No, never.
And he does cite 42 CFR Part 2, doesn't he?
Yes.
Did this case involve any drugs or alcohol that you're aware of?
No.
So let's take a look at what he disclosed to you. Are you familiar with Exhibit 836? I'll give it to you first and then we'll put it on the end. Take a look at 836, 837, 838. I know they've been modified, but are these true and accurate copies of what you received from Dr. Gechter?
Yes.
First one that you received, 836, doesn't have anything on the bottom, doesn't have any writing on it, right?
Right.
But then, as part of that, did you also receive the answer sheet that's set out in 837?
Yes.
Now, with regard to what's printed at the bottom, when you received it, did you take note of that?
Yes.
Why did you take note of what was printed down here?
Because it provided a timeline, a distinction as to why the test was administered 2 times rather than how it's typically administered, which is just 1 time.
And was that the only reason that it was noteworthy to you?
Well, it identifies in there, it gives it gives context to what the instructions were and what was given at the time in terms of what he told her in terms of when she was answering the questions, what it should be pertaining to.
And if he's administering the test twice, and those are the instructions that he gives her, is everything okay, or is there a problem for you?
There's a problem.
And why is there a problem?
Well, the first problem is that it's leading on there by identifying domestic DV being domestic violence, etc. So it's essentially saying what the trauma would be. Another problem is that they are, they're separate time frames, but the results didn't indicate that they were separate time frames.
So who cares if they're separate time frames? What difference does that make?
Because it would indicate how the rest of the test is identified and answered.
And in looking at the answers in the test, and in looking at the separate times, was there a problem?
Yes.
What was the problem?
Well, it's important to understand how the DAPS works, which is similar to the PDS. It's the same format of have you experienced these traumas. It lists out a number of traumas. Then it says, out of these traumas, which one stands out to you the most? And the trauma that stood out the most for both of these was the day of the murder.
So if the trauma is the day of the murder, how is that a problem based on what you see in Exhibit 837?
Because it's not in conjunction with how it was laid out, which is the first one was supposed to be for 2008 prior to the murder.
Did not include the murder then.
Right, prior to.
And the trauma that was identified by the defendant was what? The day of the murder?
The day of the murder.
And so, seeing that, did you note that somewhere in your file?
Yes, so I took notes on what Dr. Geffner did and the results that he gave me.
And were those notes, send them out, or did you provide them to the defense? The ones that included this issue that you had noted here.
I did it.
And after you provided those notes, did you receive something else from Dr. Geffner?
Yes, I received a letter from him and it corrected.
And so you received a letter dated December 23rd, 2014 then?
Yes,
And then you also received Exhibit 8, right?
yes.
Okay? So now what are the changes? What are we looking at here?
So essentially what the change is it allows for this overlap so as to make sense as to how it could be possible that the same trauma was listed as the most salient event.
But if you take a look at here, it does, what does that say?
DV,
And then it says,
etc.
and then it says pre-jail, right?
Yes,
And then it says down here what?
DV in general, post-jail.
The other one, does that include the notation involving domestic violence?
No,
You see it anywhere there? So not only was there a change to the timing, but there was also a change in terms of the trauma, wasn't there?
yes.
In administering a test, is it good practice to suggest to the person who's taking the test what the trauma is?
Objection misstates the testimony.
Overruled. Let me answer.
No, you want them to identify what was the most salient trauma to them.
So how does that speak to the validity of this test when being told DV in general, post-jail, DV, etc.? What does that do to the test?
I think it could be quite leading.
And so who cares if it's leading? Why do we care?
Well, you want the patient or the client to use their own judgment. And so by putting that on there, it can be quite leading, and it just isn't good practice.
And in this case, based on the note that you saw, did the defendant use her judgment as to what the traumatic event was when we looked at it in Exhibit 837? Did she use her judgment?
Objection calls for speculation, mischaracterizes the testimony.
Overruled. Let me answer.
All I can say is that she identified the same trauma, which was the murder, for both of the DAPs that she completed.
And did she anywhere identify choking as the traumatic event?
No, both of them were related to the murder.
So, for example, if we take a look at this, Dr. Geffner told us that with regard to this one, the defendant identified choking in the murder to him. Do you see that anywhere in the test that it talks about the choking and the murder?
No, and you're only supposed to identify one trauma.
Why are you only supposed to identify one trauma?
Because that's the point of the test, is that it helps hone in on the response to that one trauma. It certainly also captures just a general trauma response that could be related to other traumas, but the point of the test is to identify what event is most salient, most distressing, emotionally, it causes the most emotional turmoil for the person.
Because isn't part of the purpose of this test to see whether or not there are any indications of post-traumatic stress disorder?
Yes.
Objection leading.
Sustained.
What is the point of this DAPS test?
It's to identify the presence of PTSD.
And if you suggest, for example, 2, what does that tell you about whether or not there is PTSD?
If you suggest what?
2 events.
Well, it just...
Objection mischaracterizes Dr. Geffner's testimony.
Overruled. Let me answer.
In terms of the test specifically, you just don't do that. That's not what you do on the test. You're supposed to identify one that stands out the most. So it's not something, the two wouldn't be done. That's not the way that it's set up.
So what would happen if, as per Dr. Geffner, on the second one, that there's the choking and there's the murder, if there's a response, how can you tell the difference between the two, between the choking and the murder, if you're just looking at the results? Is there a way to tell?
You wouldn't be able to tell. That's exactly why you wouldn't do that. It would just be too confusing.
What does that talk about, the validity? How does that talk to the validity of the test?
Yeah, it's not something that, if that was the case that someone identified two on there, I wouldn't trust the results.
Well, one of the things that you just told me, though, was that there are validity scales, aren't there?
Yes,
Well, in this particular case, did you look at the validity scales?
I did.
And in that turn, what were the results on the validity scales? Was she exaggerating, underreporting?
Nope, the validity scales said that she approached the test in an honest manner, meaning that it didn't indicate that she was exaggerating or minimizing.
But if you have this issue here, how can you have that? If you're talking about two traumas and then you're having these answers, how do you reconcile that?
Just the validity indicators wouldn't capture something like that. That's outside of the scope of what they aim to do.
So in order to see or sort of understand the results, what is it that you would do with regard to something like this in the answers? Would you just look at them and accept them, or would you attempt to look at other areas?
I don't understand what you're asking.
Would you look at other tests to sort of cross-check on this?
Objection, foundation, which test?
Sustained.
Or would you just look at this, or would you look at other tests?
Well, as it stands now, I wouldn't look at it and use it for interpretation.
Why not?
Well, because of the things that we've been talking about, but also because of the way that she responded to the questions. There were questions in there that she had differential answers for them that would just not be possible if it was valid.
When you're talking about differential answers, what are you talking about?
Let me explain how the test works again. So we talked about the first part of it, but once a trauma is identified, what happens is that the next two sets of questions focus on what was your experience at the time of X trauma that was identified? Again, the one that's most salient to her. So the first set of questions focuses on, at the time of the trauma, what was your emotional experience? Capturing anxiety, fear at the time of the trauma. Then it also asks, what are experiences that happened at the time of the trauma? So I keep emphasizing at the time of the trauma because that's the important part to me. That would make it static, meaning that no matter what, it can't change. No matter how much, I'm thinking about like my own patients, no matter how much treatment they've gone through, even though if they've healed and they're better from having PTSD, when they think back to the actual trauma, what they felt at the time, that's not going to change. It's a static variable that happened in their life.
One of the things that Dr. Geffner talked about was number two was that there was a choking component to it. Did you talk to the defendant about any alleged choking incident between her and Mr. Alexander?
Yes, she told me about an incident.
Roughly when did she tell you that it occurred?
In April of 2008.
And did she give you a date or just April of 2008?
Off the top of my head, I'd say that she just said April of 2008. I could check my notes though.
And she talked about a choking incident to you that day?
Yes.
And did she describe to you what happened during that choking incident?
She did.
What did she tell you?
She said that she had a conversation with Travis about their sexual partners because she was concerned about contracting an STD because at that time they were sexually active with one another. And she said that he was very upset about the conversation and flew into a rage and put her down on the floor and started to choke her. She described being afraid for her life at that time. And she said that as he was choking her, in order to protect herself, she tried to scratch up at his face, but stopped because she didn't want to hurt him.
And what do you make of her not wanting to hurt him when, according to her life is in peril?
I mean, it's not a typical response at all. That's just illogical. If
Objection calls for speculation. Now she's just fantasizing about what Miss Arias might do.
Overruled.
Go ahead.
when somebody's life is in danger, there's different people respond differently. They may try to get away. They may freeze.
I'm going to object to 702. She doesn't have the expertise to give this opinion.
Approach, please.
You were describing a fight or flight syndrome, right?
Objection mischaracterizes her testimony.
Overruled. Let me answer that question.
Yes.
Is that something that you learned in school?
Yes.
Is that something that you are trained on as a psychologist?
Yes.
Is that something you've learned or also during your clinical internship as well as during your work?
Yes.
So describe it for me.
So when people are in fight or flight, there's 3 different modes that they typically go into. Fight, literally fight off the person or thing that's coming after them. Flight, run away, or freeze, not do anything.
So in this case, you indicated that the defendant fought, right?
She said that she started to.
And then you indicated the response was illogical, and then you started giving us this explanation, right? You explained what you were trying to tell us.
Well, illogical in the sense that he said that she started to fight, but then quickly pulled away because she didn't want to scratch his face. So if she was in fear, like she described, that's just not a response that most people would have at all. She's trying to fight for her life.
Now, we were talking about the DAPs, and you were talking about some of the emotions that were associated with it, and you indicated that they were static. Looking at questions 15 through 22, and if you have them there, why don't you go ahead and give them to me so that I can mark them?
The answers?
Yes, the answer. Do you have them for me?
Which ones do you want?
Both.
All 3?
She actually had 3, is that what you're saying?
Yes. So this is the corrected that you have up there.
Correct.
And then these are the original 2.
And let's go ahead and mark them. And let's take a look at Exhibit 865. Is this the 3rd answer sheet that was provided to you, or the 2nd?
This is the third.
Take a look at that, which is the last one that he sent me, right?
Yes.
With regard to questions 15 through 22, you indicated that they refer to some sort of emotional experience, correct?
Yes.
And what are the emotions that are discussed?
They're related to, I'm going to turn to the actual,
Just
a general. Just related to disgust, anxiety, fear, horror.
Okay. What about question number 15? What does that refer to?
Can I reference?
Sure.
I'm going to ask if that is not marked, that it be marked.
Yes.
I'm reluctant to give this to you. This is the actual test questions.
We're not going to show it. We'll just mark it. And this is the same issue as with.
Right, and we will return it to you.
And I do have to give it. This is the actual test question, so.
Sure. Will Exhibit 868 refresh your recollection as to the answers of these particular questions?
Yes.
We're talking about question 15. What is the emotion there?
Fear.
And specifically, what is she being asked, without giving us a specific question, what is she being asked about fear?
These first set of questions pertain to at the time of the event that was identified, which was the murder. What was your emotional experience related to this one being fear?
So even though 2 tests were given, and we have the times here, would her fear change, even though she was given these 2 time limits?
No,
Objection calls for speculation. Lacks specificity is what's in the question.
Overruled, you may answer.
I would not expect it to change because the event is identical and the emotional experience is not the emotional experience now, it's at the time of the event.
And that's what the question calls for, right?
Yes.
So in terms of and I'm just going to call it number 1, the fear component, what did the defendant report was her fear at the time of the murder of Travis Alexander?
Well, on one test she indicated that it was very much, so this is on a scale of 1 to 5.
Let me stop you there. Which test did she indicate that was very much? Was it the one that I'm calling 1 or the one that I'm calling 2?
I'll stick with 1. So number 1 that's on the screen.
This one right here.
Yes.
What did she say was her fear?
So on a scale from 1 to 5, it was 5.
Which is what?
Very much.
So then on the same day that she was given that test, when she was asked about the same emotion involving fear, involving the same event, which is number 2, what was her fear?
A little. 2.
How can it be that her fear for an event changed? How can it be for the same event?
Objection calls for speculation.
Overruled.
It's not possible.
And so what does that tell you about the validity of the test?
This is the reason why, the main reason why I don't think this test can be relied upon.
How about question number 20? What is the emotion that's being discussed there?
Disgust.
And it's her disgust at the time of the murder, right?
Yes, all of these pertain to at the time of.
And so we're looking at this, it says including the date of the murder for the first one, and the second one says including day of the murder also, right?
Yes.
And the trauma that's identified is the same for both of them.
Yes.
So her answer on the first one was what?
She had some disgust, being a 3.
So she was just she was some disgusted at the murder, right?
Yes.
And How about the second one? What was her answer to that as to her disgust?
5, very much.
So what she's saying there is she's saying, well, correct me if I'm wrong, she's saying she's more disgusted about the murder now than then?
Objection, different time periods. It's not equivocal. It's not an appropriate question.
Overruled. You may answer.
According to the time frames that he has listed here, that would be a potential interpretation, but again, this is supposed to be at the time of, so it's still illogical. It doesn't make sense the way that it's answered.
Should the answers be the same?
Yes.
How about question 21? What is the emotion that's being talked about there?
Upset.
And how upset she was on the day of the murder, and what did she say as to the first answer?
For number 1 here, it was 5, very much.
And how about number 2, about the murder, what was her answer then on the second one?
Some, which would be a 3.
Again, if we're talking about the same event, does the question say anything about anything other than that it being a static event?
I'm going to again object. It mischaracterizes Dr. Geffner's testimony and his use of the test.
Overruled. You may answer.
I didn't understand your question. Can you ask it again?
What's that?
Can you ask the question again?
With regard to these answers, how do you reconcile them? Is there a way to reconcile them or not?
No.
Same objection.
No, there's no way to reconcile them.
Overruled.
Why not?
Sorry. They're different answers to this. It's the same question about the same event, and there's static factors that would not change.
But there are validity scales here, aren't there?
There are.
And so these validity scales, don't they indicate that something? I mean, what's their value?
Their value is to identify whether someone is exaggerating or minimizing their symptoms, and they do that by certain questions that are asked. This is not something that would be captured in the validity scales. This is looking at information across 2 administrations. There's no validity scales that looks at that because you don't really need it to say that it's invalid. I could look at it and see that there's different answers and know that that makes it invalid.
How about questions 23 to 28? What did they talk about?
So that focuses more on experiences that would have happened at the time of the identified trauma.
The previous one we discussed was emotions.
Emotions.
This is experiences.
Yes.
Did she talk about those experiences in question 25?
Yes.
And with regard to the experience in question 25, what are we talking about?
This is related to just a feeling of being strange, unreal.
And what was her answer with regard to, number 1, the day of the murder?
Very much 5.
And what was her answer about the day of the murder in number 2?
2, a little.
Again, can you reconcile the 2 of them in light of what the test calls for?
Same objections mischaracterizes Dr. Geffner's use of the test.
Overruled.
No.
And what does that tell you about the validity of the test?
You can't trust the results.
How about question number 26?
That question pertains to change in bodily sensations.
And what does she say about her bodily sensations as to number 1 and the murder?
2, a little.
And this one right here, the second one, what was her emotion?
1, not at all.
But if she's talking about the choking, how does that figure in on this? Is there any way to see which one she's talking about? For example, maybe in this question she's talking about the choking. Would there be any way for you to know what she's talking about?
Objection, compound question, calls for speculation.
Overruled. You may answer.
No.
So, how about question 27? What does that talk about?
It pertains to the experience of time. and how time went by during that time.
What did she say about time with regard to the date of the murder?
That would be 5 very much.
And the other one, what did she say about that?
3, some.
But in question number 14 on the deaths, it does, the question, well, take a look at Exhibit 867. Oh, you do have that. 14. It asks the person to identify. Does it ask the person to identify the traumatic event?
Yes.
And did she identify the traumatic event?
Yes.
And what, for both of them, what was the date of the traumatic event?
June 4th, 2008.
You did administer, I think, the TSI, didn't you?
Yes.
Did you administer it for 2 different periods of time or not?
Yes.
Well, isn't that sort of the same thing that he's doing here in 867? How is that different?
The way that these questions are set up is that you identify one specific trauma and then the subsequent questions are related to that trauma. In the TSI, it's more general. It's not specifically related to one trauma.
And what's the function of the TSI as opposed to the function of the DAPS?
The DAPS is just more cleanly mapped on to the actual diagnosis of PTSD, whereas the TSI, which is the one that I did, is more of just general symptomology that can be seen in PTSD, absolutely, but can also be seen in a number of different disorders.
Dr. Geffner also administered the CTS, correct?
Yes.
And that's the conflict tactics scale, correct?
Yes.
What does that focus on?
It identifies a number of different maladaptive behaviors that could occur between 2 partners, including violence.
But does it just focus on one of them, or does it focus on both of them? What does it do?
It asks about both of their experiences of it. So it would ask the person taking the test, have they ever done X? And then has their partner ever done X? So it looks at both sides.
So question number 21 of that test, do you have that in front of you or not?
No, I don't.
Please pull it up.
Okay. Take this. Okay. Oh, it looks like I put another one away. Oh, this is the actual questions that you said I could keep.
Right, but it has a tag on it.
Just leave it out. Okay.
And if I can get the other one.
This one?
Yes.
That one also has questions on it.
Ladies and gentlemen, we're going to take the noon recess. 1:25, please return. 1:25. Please remember the admonition. Have a nice lunch.
All rise.
Council approach, please.
The October 30th.
Yeah, we're off the record. That October 30th transcript, I left it right here. You put it. Yep. And here are the juror questions. You don't want these?
No, I mean, I don't know what the, are we on the record?
No.
Oh, I'm not sure what the court was bringing those up for. I don't believe that she has.
able to answer those questions.
She can't, but I thought you might want to see what the jurors were interested in knowing.
Okay.
I mean, to me, that's the
It seemed like you
benefit.
raised it as an issue. Okay.
Okay, no, if you don't want to look at them, you don't.
I actually
Okay.
don't think it's proper for either party to have them, given that she didn't complete her testimony. I don't think the state should have them either.
Well, it's a public record, and since there was no cross-examination, I think that it is appropriate. We typically don't provide them until the end of the testimony, which has already occurred. So they obviously won't be asked, but. Okay, we're going to talk to the juror. We'll have to have the sweep done, but we're going to talk to the juror first thing after the break.
Oh, after.
After the break.
125 minutes?
Yeah, 125. Can you tell Gabe you need a sweep by 125? Thanks. Okay. Have a seat.
And, Your Honor, if the court recalls, before we broke for lunch, we wanted to make record of the objections related to the transcript of October 30th.
Yes.
We have reviewed the transcript. I'm asking, basically the substance of my request remains the same. The pertinent concern becomes the comments of Miss Arias herself, which are contained in pages 17 through 22, and she makes some comments on line 27 as well. And I can see from my notes.
I'm sorry, 17 through 22, and what was the last?
She made some comments on page 27 as well. And I say in my notes, I see I neglected to note the line numbers as it relates to page 27. My request with page 17 to 22 is inclusive of all lines of those pages. And for 27, page 27 is just denoted with the comments from Miss Arias. And I can show the court if the court wishes.
I have it here.
Okay.
I have it here. All right, I will review that and issue an order. Let's bring in the jury.
All rise for the jury.
Please be seated. Record shows the presence of the jury, the defendant, and all counsel. May continue with direct examination.
In the time that you've been practicing, have you ever been named, or has your company ever been named in a lawsuit involving any sort of misconduct involving any of your patients?
No,
And during that same period of time, has there ever been a lawsuit that may have just mentioned you as a named defendant involving issues related to sexual harassment?
no,
Before we left, we were talking about the CTS, right?
yes,
And that's the conflict tactics scale test, right?
correct.
I'm approaching with 869. 869 is what?
You asked what it is?
Pardon?
It's the conflict tactic scale.
But what is it, the answer sheet?
Yes, it's the questionnaire that she filled out that includes the questions on there.
And with regard to the conflict, or the CTS for short, the questions as they relate to the answers, do they call for just one person, or do they call for a partner, or how are they phrased in terms of the answers?
Objection, compound question.
Sustained.
Is the partner included?
Objection, foundation included in what?
Sustained.
In the question.
The partner does not fill it out. One person fills it out, but they're filling it out as it pertains to their own behavior and their partner's behavior.
So with regard to question 21, what does that deal with?
It's related to using a knife or a gun on a partner.
And what was her answer as to whether or not a gun or a knife was ever used?
She indicated that she's never done that. Never used a knife or a gun.
So the answer was never.
Right.
One of the things that Dr. Geffner said was that, well, that needed to be looked at. Is there any way to take a look at this whole test and reconcile that she says that she never used a gun or a knife with that answer?
Can you ask that question a different way?
Is there any way to reconcile that answer knowing what you know about the murder?
No.
Was there a gun that was used in this one as far as you know?
As far as I know, yes.
And a knife?
Yes.
So, question 48.
Question 48 pertains to using force to have sex.
And with regard to the Geffner test, which is the CTS, what did she answer?
But that's never happened.
In other words, she's never been forced to have sex, right?
Yes, according to how she responded on this one.
Is she, as we look at that, is she talking about all of her relationships, as you know, or is she just talking about the relationship with Mr. Alexander?
Objection, compound question, calls for speculation.
Overall, to me, answer.
It's not indicated on here whether it's in relation to just him or all relationships.
And you know there was another female psychologist that was involved in this case, correct?
Yes.
Did she administer something called the partner abuse scale?
Yes.
And that has a sub-portion of physical, correct?
Yes.
And it also has a non-physical component?
Yes.
Are these same type of questions asked?
Compared to the CTS?
Yes.
There's some questions that overlap, yes.
With regard to question 48, as it applies to that female psychologist, if you take a look at question number 1 from this other psychologist, the question that we just talked about, do those questions overlap?
Your Honor, she's again referencing some of the notes that we'd like to have marked.
Yes.
These again have test questions in them.
I understand. This is Exhibit 870, that relates to the questions that I'm asking you involving the other psychologists. Why do we even need to look at somebody else's tests and responses as we're looking at questions, for example, like 48? What's the utility of that?
What I'm looking for is just consistency in reporting.
Okay, and so with regard to the other psychologist, the partner abuse scale, physical, question number 1, what was that question?
The question was very similar, pertaining to being physically forced to have sex.
And what did she say? And by that I mean the defendant. What did she tell this other, or what did she write for this other expert? What was her answer?
Her answer was some of the time.
So some of the time she was physically forced to have sex.
Yes.
Is that consistent or inconsistent with the answer that she gave Geffner?
Inconsistent.
Question 31 with the CTS and Gaffner, question 31, what does that deal with?
It pertains to seeking medical help as a result of an altercation with a partner.
And does the partner abuse scale physical, question number 5, deal with the same thing?
Yes.
And what's the question there?
Similar. It's related to after my partner beats me, I must seek medical help.
With regard to Gaffner, what did she answer on his test? That would be, did you get the, go ahead.
Can you tell me the number again?
Is it 31 or 48?
It's 31.
Right.
She indicated that that happened once.
Okay.
Oops, I read the wrong one. I apologize. She indicated that that never has happened.
And with regard to the partner abuse scale involving question number 5, which you told us what it was, what did she say?
She indicated that it happened, but very rarely.
So one she says never, one she says rarely.
Yes.
Talk about question 52, what is that asking?
52 on the CTS pertains to insisting that she has sex when she didn't want to.
And to Gettner, what did she respond?
6 to 10 times.
And on the partner abuse scale, non-physical, what was her response to question number 17? First of all, what's question 17?
Similar. My partner demands sex, and the answer was all the time.
Objection foundation, the distinction of these questions, the comparison.
Approach, please.
Again, what was your answer with regard to the partner abuse scale, non-physical, from the female psychologist?
That was related to demanding to have sex, and the answer was all of the time.
Did Gettner provide something called a personal problems checklist to her?
Yes.
Do you have that with you?
Yes. This one also has questions in it.
All right. Take a look at Exhibit 871. What is a personal problems checklist?
It's a self-report measure that lists a number of different potential problems that the person could be experiencing in their life. What they're asked to do is just put a check mark next to the areas that they are having difficulty with, and in each subsection, they're supposed to circle the one that stands out to them the most and feels most problematic.
Did you take a look at question number 5 on that one?
Yes.
And what does it deal with?
This pertains to acting rude and overbearing.
And what did she say about acting rude and overbearing?
She indicated that this was one of the areas that she had problems with, and in fact circled that as being the most problematic.
And what was her answer? In other words, word for word, the answer. What was her answer? Can you give us that? The answer?
It was pertaining to acting rude and overbearing.
Right. What was the answer? Word for word. That's on that she gave us. Can you give us that or not?
Well, that would be giving you the exact question.
Can you give us the
No.
exact? No? Okay, then what is, and paraphrase for us, what is it that she said?
she didn't write anything. There's different different areas that are problems in someone's life, and she essentially checked off the one that's pertained to acting rude and overbearing.
And with regard, and she indicated she was rude and overbearing.
Yes.
Okay. Okay. Let me show you a couple of exhibits. As it applies to this particular issue about being rude and overbearing, take a look at Exhibit 872. Do you recognize that?
Yes.
It does say privileged and confidential attorney work product. Do you know where that comes from?
I had made the assumption that this came from the defense.
And there's a letter that you were provided that showed something to that effect, wasn't there?
I don't recall that.
All right. With regard to 872, is this a redacted portion that deals with the issue that we're talking about, aggressiveness and overbearing?
Yes.
Okay. Look for the admission of Exhibit 872.
Can we approach, Your Honor?
You may. Gentlemen, we need 10 minutes. Please go back to the jury room. Please remember the admonition. Thank you. No. Okay.
Your Honor, for the
Hold on. Come on up, please.
Your Honor, I do have the case citation for you.
Okay, go ahead.
215 Arizona 514, cases Pandelli, Pandelli. It references, I believe, Chambers v. Florida to my recollection, and also
Got it.
cites the ARS 13752G. Your Honor, if when substantive discussion arises, I'd ask the witness to step out of the room.
Okay, I found the pertinent paragraph. It is paragraph 43.
Yes, Your Honor.
It says trial courts can and should exclude evidence that is either irrelevant to the thrust of the defendant's mitigation or otherwise unfairly prejudicial. Nothing in our death penalty statutes strips courts of their authority to exclude evidence in the penalty phase if any probative value is substantially outweighed by the prejudicial nature of the evidence.
Right.
Trial courts should not allow the penalty phase to devolve into a limitless and standardless assault on the defendant's character and history. Rather, trial judges should exercise their broad discretion in evaluating the relevance of such bad act evidence to any mitigation evidence offered. A judge's analysis in determining the relevance of rebuttal evidence involves fundamentally the same considerations as relevance and prejudice determined under Arizona Rules of Evidence 401 and 403.
Your Honor, again, before argument on this issue takes place, I'd ask that the witness again renew my request.
Dr. DeMarte, would you please wait outside? Thank you. All right, the record will show that Dr. DeMarte has left the courtroom. All right, so, counsel, do you have anything else to add?
Sure, Your Honor. I mean, I find it hard to say how this, a limitless, standardless assault on the defendant's character would not take place when, if the state is allowed to proffer evidence of the, that is contained, I believe, I don't know whether it's second or third, but the last sentence where it says she is, quote unquote, a total bitch. That sounds to me like a standardless assault on character, the kind that is inconsistent with the due process. There was no testimony in that regard, contrarian testimony. And again, that is just name calling. That is not Dr. DeMarte bases her opinion on name calling. That's an issue for her, but I think it's an issue for this court when we talk about just starting to call people names.
Martinez?
I would note that the person who made that statement is somebody who grew up with a defendant, somebody by the name of Amy Lance. She's the defendant's cousin, Her mother is Sharon, the eldest of Sandy Arias' sister, and she also details how they would grow up. One of the things that they would do when they would growing up is they would attend family functions. And taken in context, it says, at family functions, Jodi would be snide. She could say things sarcastically and with a snide smile. She could be a total bitch. This is not an assault on the defendant. This is just indicative of the attitude of this individual that others, Fonseca and Geffner, have indicated is not aggressive, that is a person who suffers in silence. They indicate that she's passive. This is just to allow the jury to take a look at both sides, one by a family member and one by a psychologist, and another one by a psychologist who did not testify as a psychologist. I do believe that applying 401, 402, and 403, clearly it's relevant. And is it unduly prejudicial? I do not believe it is unduly prejudicial in light of the many hours that were spent by both Fonseca and Geffner arguing that the defendant was somebody who could never be this individual other than somebody who is a wilting flower. So for those reasons, I think it's admissible.
And Mr. Martinez, Dr. DeMarte, what will her testimony be with regard to the significance of this particular statement?
That this is something that was mentioned in Geffner's, whatever the sheet was, I can't remember what it was, that she can't give us the name of, but it's the personal problems checklist, and in it, it says that the defendant was rude and overbearing. That's what she testified. Geffner didn't address it. I'm just bringing it in to address it to show that there are two sides to the story.
So she will testify that this particular statement validates the test results?
No, she will testify that this validates that, according to that, because it was something that was filled out by the defendant, validates that she was rude and overbearing, and of course Geffner never touched on it. And he should have. And she also used it in reaching her now to confirm that this is borderline personality disorder.
So then this information would be used for two purposes.
Right.
In addition to rebut prior testimony
Right.
by Dr. Fonseca and Dr. Geffner.
Right.
All right.
Well, that mischaracterizes, first of all, the testimonies of Drs. Fonseca and Geffner, and the fact that Dr. Fonseca specifically testified that she was not a wilting flower that would always take things, that she did have outbursts. When the state asserted that it was okay for Bill Arias to slap his daughter, but not okay for Jodi Arias to respond verbally to that, Dr. Fonseca explained to the state that people who suffer in silence can also be prone to outbursts of this nature. And Dr. Geffner further himself said that that was not always the case with her, and that she would not ever speak up for herself. The issue, I might add, Judge, if this is the stated purpose, that she is not always passive, etc., that the state has proffered here this afternoon, I would say that that is accomplished by the talk about Miss Arias being snide and sarcastic. I would question the idea of this conclusion that she's a total bitch being anything but name calling. So I think the stated purpose, without the prejudicial effect that is displayed in Pendelli in the case law they cite, it does become a limitless assault on Miss Arias' character. We heard about it, and we've heard about it now, and then throughout the course of the state's rebuttal case. Well, she's a liar. She's a total. Now they want to go with total bitch. I wonder what's next. But I don't think it's appropriate under the case law. The other stuff, arguably, you could make the case that it's relevant in that regard, although we would maintain our dispute with that relevancy. But the last sentence, that she's a total bitch, is meaningless other than to assassinate Miss Arias' character.
All right, for the reasons stated at the bench previously, I'm going to overrule the objection. I find that the testimony is relevant for all of the reasons stated on the record, and I find that the prejudice does not outweigh the probative value. All right, so we're going to bring back in the jury. Proceed. I'm going to admit. So, also, just so we're clear, Mr. Martinez, you will need to lay some additional foundation for 872 and offer it again. Not admitting it yet. I'm just saying if you lay the appropriate foundation as we discussed.
Just for clarity's sake, he's not seeking 873, just 872.
And 873 would just be used to refresh her recollection. She needs it as to who Amy Lance is.
Be seated. The record will show the presence of the jury, the defendant, and counsel. You proceed.
In terms of 872, do you know who Amy Lance is in terms of your information? Who is she?
She's a cousin of Miss Arias.
And did she grow up with Miss Arias?
Yes.
And did they attend family functions and that sort of thing?
Yes.
And they grew up together?
Yes.
I move to the admission of Exhibit 872.
No additional objections other than those already made.
All right, 872 is admitted.
Take a look at 872. The date on it is what?
10/24/08.
And it does say that, what does it say here? That sentence that's there.
Amy is Jodi's cousin. Her mother is Sharon, the eldest of Sandy Arias' sisters.
And what does she say about the defendant and family functions?
Would you like me to read it?
Please.
At family functions, Jodi would be snide. She would say things sarcastically and with a snide smile. She could be a total bitch.
In terms of this aggressiveness and rudeness that you mentioned to Detective, I'm sorry, that you mentioned to Chapman, do you know who Carolyn and Sonny Allen are?
I'd have to see the paperwork that you're looking at.
Why don't you go ahead and take a look here? Exhibit 846.
Oh, yes.
Four of them.
Maternal grandparents.
And her maternal grandparents, they had some comments about the rudeness and aggressiveness of the defendant also, didn't they? Yes. And is that contained there in that exhibit in front of you?
Yes.
I move for the admission of exhibit 876.
May we approach, Your Honor?
You may.
Take a look at exhibit
Mr. Martinez, I'm going to admit 874 and 876.
Let's take a look at, first of all, Exhibit 876. What's the date?
10/24/08.
And what does the statement say here?
Caroline and Sonny are Jodi's maternal grandparents.
We can take a look at the back page. Why don't you read for us what they said?
Jodi was very mean to Sandy. Jodi always told Sandy how to raise Angela and Joey. Sandy couldn't do anything right by Jodi, and she was always angry at Sandy. No one knows why.
Take a look at Exhibit 874. Again, read this correctly.
Caroline and Sonny are Jodi's maternal grandparents.
And what else does it say?
Jodi didn't want anyone running her life. If you talked to Jodi, you had to use perfect grammar and speech. She corrected everyone.
In terms of this aggressiveness, do you have other examples of the defendant being aggressive in her life?
Objection mischaracterizes the testimony.
Restate your question. Sustained.
You indicated that the personal problems checklist indicated acts of being rude and overbearing, and that was the defense.
Objection mischaracterizes the results of the test.
Overruled. You may answer.
Oh, that's not right.
Yes.
And we saw some examples of her involving that issue. Did you characterize that as aggressive or not?
Those examples would be characterized as overbearing and aggressive.
And in terms of her aggressiveness and or assertiveness, do you have any examples as it relates to, for example, the defendant in her personal life involving the memorial service or traveling to the memorial service?
Well, I have several different examples of her being assertive, but specific to traveling to the memorial service, there in the records it indicated that on her way back from the memorial service, she had had a conversation with a man on the plane and had got his phone number, and as soon as she got home, she called him.
And do you remember that individual's name?
I don't.
What about people? Are you familiar with the Purple Pond where she used to work?
Yes.
Do people have opinions as to her assertiveness?
Well, they described her as...
Objection. May we approach?
You may. All right, ladies and gentlemen, we're going to take a 10-minute recess. Please remember the admonition. You are excused. Counsel, are you ready?
Yes.
All right, let's bring the jury. Please be seated. The record will show the presence of the jury, the defendant, and counsel. Mr. Martinez, you may continue.
Exhibit 800, ma'am. This is an excerpt from a larger document, correct?
Yes.
And the comments that are there after reading the larger document, do they refer to the first time she worked at the Purple Plum or the second time she worked at the Purple Plum?
The second time.
But you look at the admission of exhibits 800, 878, and 881.
Same objections already lodged, Your Honor.
I think it's actually 880, isn't it, Mr. Martinez?
I have 881.
All right, 881, 878,
Right.
and was there another one?
881. There was just three.
Your Honor, I don't know that I've seen 881.
Mr. Martinez?
We approach, Your Honor?
Yes.
You're aware that Dr. Fonseca testified that the defendant lacks self-esteem. Are you aware of that?
Yes.
And are you aware that Dr. Geffner also testified that the defendant lacks self-esteem?
Objection mischaracterizes the testimony of both Dr. Fonseca and Dr. Geffner.
Overruled.
Do you know that?
I'm aware that they talked about it in their pretrial interview. Yes.
And with regard to these, what you have in front of you, 881, does that go directly to that issue about low self-esteem involving the defendant?
Yes.
And it's something that you consider in whatever opinion you have today.
Yes, that's correct.
I move for the admission of Exhibit 881.
Same objections as previously lodged, and as it relates to publication, I don't think it's appropriate for publication at this point in time.
All right, the objection is overruled. Exhibit 880 is admitted, and we will need to have a copy made before it can be displayed on the screen. You may.
Let's take a look at Exhibit 880. of all, give us the date,
10/25/08.
and it's an interview with whom?
Gary Brinkman.
And read the first line for us, please.
Gary and his wife, Jean, own the Purple Plum restaurant in Wairika.
And the second point,
Gary has known Jodi since she was 17 years old when she applied for a job as a server. There were no openings at the time as she worked briefly bussing tables at PP. Jodi then went to work for her parents at their restaurant in town.
what does it say next?
He did not see Jodi again until April of 2008 when she applied for a waitress position.
And then what does it say?
She would go right to the men and would ignore the women and other customers.
And what else?
Much more friendly and flirtatious with the good-looking guys.
Take a look at the second page of Exhibit 880. What does it say?
She used men. He gave an example. A local man came in PP and Jodi pretended she moved here and knew nothing about Wairika and asked him to show her around. She lied about that.
Take a look at Exhibit 878. And the date on that is,
4/29/09.
and it's an interview with whom?
Jodi Arias Zimmaran. I don't know how to say the last name.
And what does the first paragraph say?
I met with Julie in her home in Hollister, California. She is Jodi's half-sister with Bill Arias as their same biological father. Julie is married to her second husband, Eric, who is a supervisor at Semiconductor Tooling in San Jose. Julie has 3 biological children, ages 3, 4, and 12, and a 13-year-old stepdaughter.
And if you go to the second page, what does she say?
Jodi took a plane to attend Travis's memorial, and on the way home, she stopped at Julie's. On the plane, Jodi met some guy, Nick. She sat next to him on the way back to Sacramento from Phoenix. She gave this guy her name and phone number. She had his phone number, too, and she called him when she got to Julie's house.
In terms of this issue about the assertiveness that we've been talking about, let's take a look at exhibit number 489 and ask you whether or not this speaks to the defendant's assertiveness or not, because it's already in evidence. You can see that it, what's the date on it?
1/18/08.
And it does say incoming, right?
That's correct.
And what is she writing?
Would you like me to read it?
Please.
Will do. The reason I was asking about later tonight is because I want to give you a nice VJ, and I'd like a generous facial in return. What do you say?
And then what does she say on the next incoming?
Or we can just grind?
And the outgoing message says what?
That's a good close. And
one of the things you indicated to us was that you worked with SVPs previously, correct?
Yes.
And you're familiar with some of their terms. In terms of facial, what is a facial in this context?
In this context, it appears to be referring to a male ejaculating on her face.
Are you sure it's not a male placing his face between her eyes?
Objection asked and answered, argumentative leading.
Sustained.
Have you ever heard of that?
No.
Is this an indication at all about her assertiveness, the defendant's assertiveness, and so how?
Yes, that she was asserting her desires and her wants and needs.
And in what arena?
In a sexual capacity.
And with whom? You know that this involves Travis Alexander?
Yes, with Mr. Alexander.
Take a look at exhibit number 494. Again, what's the date of that?
2/25/08.
And what does say there?
If you're a lucky boy and you promise to give me a good, well-deserved spanking,
And what does it say after that?
maybe you could give my ass a much-needed pounding, too. Kidding.
Again, we're talking about, does that speak to the defendant's assertiveness, whether or not she's assertive or not?
Yes.
Objection leading.
Overruled.
Does that talk also about her self-esteem?
This one in
Objection leading.
Overruled. Let me answer.
Does it?
This one in particular, no.
How about the previous one? Does this talk about her self-esteem, exhibit number 489?
No.
And 495, what is that? Can you read it for me, please?
Oh my gosh. That is so freaking hot. I want to lick it up and then sit on it. You are so tasty. My goodness.
And the date of the response, what's the date?
2/26/08.
And what does Mr. Alexander respond?
I'm glad you like it.
And then what does she respond?
Oh yes, I want to fuck you like a dirty, horny little schoolgirl.
And does this speak to her assertiveness?
Yes.
And what does it tell you?
These in particular that we just went over is related to in the sexual arena, that she was certainly assertive with her sexual desires.
And she was, if she's corresponding with Mr. Alexander, what does that say about the relationship between her and Mr. Alexander in terms of this assertiveness that we've been talking about?
Well, that they certainly had a relationship that allowed for such conversation, that talking about their sex life, that there was an open communication between the two of them.
Does it talk to whether or not this was a one-way street where Mr. Alexander dictated when, where, and by force? Or does it speak to something else?
Objection compound question.
Sustained.
Does this speak to Mr. Alexander dictating the sexual workings of their relationship?
Objection foundation, what workings?
Overruled. Let me answer yes or no.
Can you ask that question again?
Does this speak to Mr. Alexander being in charge, or did she have a say-so on what was going on?
Objection compound question.
Overruled. Let me answer.
She was engaging in it. She certainly was expressing her desires and wants from him. It was not purely dictated by him.
Are you familiar with an audio tape that was recorded by the defendant involving her and Mr. Alexander engaged in what's commonly known as phone sex?
Yes.
And in that tape, does that talk to you about the assertiveness, sexual assertiveness of the defendant in the relationship with Mr. Alexander?
Yes.
Objection, Your Honor, may we approach?
Yes.
You got the last question.
And in that tape, does that talk to you about the assertiveness, sexual assertiveness of the defendant in the relationship with Mr. Alexander? Yes.
With regard to that, can you give us any examples of how the defendant was assertive in that tape?
Well, she was talking about her sexual desires and needs. And
Specifically what?
at one point, she had asked that he not have an orgasm so that she could have an orgasm.
Okay, what else?
She was expressing what she was interested in and what she would do with him and what he would do with her. There was just an open conversation about their sexuality together.
Any other examples other than the one that you just gave us about asking him to wait to have his orgasm?
No.
Now, throughout this thing, there has been this issue about physical abuse. Did you find anywhere in the journals that there was any mention of any physical abuse by Mr. Alexander on the
No.
Did you speak to anyone who ever saw any physical abuse suffered by the defendant at any basis? In other words, a relationship of boyfriend and girlfriend.
Objection, compound question.
Sustained.
Did you see any indication, any individual that said Mr. Alexander had?
Objection, foundation.
Overruled.
No.
In terms of the allegations involving the physical abuse, where did that source come from?
Miss Arias?
Anybody else other than Miss Arias?
No.
Did you discuss with her, well, the journals, they don't indicate anything about domestic violence. Did you ever talk to her about that?
About why it doesn't indicate?
Right.
Not.
And was it telling or important to you as a psychologist that it did not, that the domestic violence was not included anywhere in the journals?
Only in the sense that she tended to document quite a bit in her journals.
When you say she tended to document quite a bit, what are you talking about?
She wrote a lot in her journals. She talked about her daily activities and what was occurring.
Were there any police reports that were brought to your attention of any physical violence between Mr. Alexander and the defendant?
No.
Any medical records, anyone?
No.
So in terms of the issue of domestic violence, what does it rest on for you as to whether or not there was domestic violence? What does it rest on? Where do you need to go to determine whether or not there was? What's the root of it?
Well, what I have to rely on would be consistency of her reporting.
In other words, you have to look to her word, right?
Yes.
And if you look to her word, did you find anything, for example, just anything that corroborated this allegation of domestic violence?
Objection, asked and answered.
Overruled.
In terms of her word, in terms of her consistency?
Not just in terms of her word, and then out there in the community, reports, that sort of thing.
No.
Objection, asked and answered in a compound question.
Overruled. Give me answer.
Anything in anywhere else.
No.
In terms of corroborating, in other words, she did have conversations with you about it, right?
Yes.
She had conversations about it with the other female psychologists, right?
Yes.
And in terms of Richard Samuels, she also talked with him about it, right?
Yes.
In terms of the corroboration or lack of corroboration, what she described to you in terms of the domestic violence, was it the same thing that she described to the other psychologists, the female psychologists?
No.
How was it that she was inconsistent in her reports to the other psychologists?
Objection, foundation. She doesn't know what was said.
Sustained.
Well, you read her reports, didn't you?
Yes.
You saw her test results, didn't you?
Yes.
Didn't you see the trauma symptom inventory?
Objection, leading.
Sustained.
Did you see her tests?
Yes.
And I'm talking about the other one. Did they talk about trauma, the test that was given by the other individual?
Yes.
What was the name of that test?
The TSI?
And what else did she give? Did she just give that one, or did she give something else?
No, she gave several others related specifically to domestic violence, the partner abuse scale, both the physical and non-physical.
Right. So all of these tests, you looked at them, and you said they were pencil and paper tests, right?
Yes.
And they asked about whatever the physical violence may have been, right?
Yes.
Objection, leading.
Overruled.
And with regard to, you said, well, was she reported to, and was there a clinical interview also with the other expert?
Objection, compound question and leading.
Overruled. Give me answer.
That's it?
Yes.
And did this other individual, this other female psychologist, did she have notes attached that were provided to you for your review?
Yes.
Did they talk about the defendant telling this other expert about the domestic violence?
Yes.
And was there a report associated with that?
Yes.
And did you look at this report? And did he talk about what the defendant said about the domestic violence?
Objection, leading.
Overruled.
Did you?
Yes.
And in terms of seeing that, was there corroboration or was there lack of corroboration of the defendant's statement?
Objection, foundation as to which statement?
approach. Overruled.
Please read it back.
Question, and in terms of seeing that, was there corroboration or was there lack of corroboration of the defendant's statement?
Lack of.
And give me examples as to why, involving this female psychologist and what the defendant told her, what was this lack of corroboration?
One example would be she talked about with me that there was one incident of domestic violence, which would be in January of 2008. In talking about that same event with the other psychologist, she identified it at a very specific date, which I believe was, I know was February, I believe it's February 6th or 5th of 2008.
Okay. And what was inconsistent about it?
Well, the first thing that was inconsistent was the date, and she gave a specific date.
With regard to you, when she gave you the date, what date did she give you?
For me, it was general. She said January of 2008, and she said it was the day after she had walked in on Mr. Alexander.
So if the date that she walked in, or if we've been told that it was January 22nd, but that's the day after she walked in on Mr. Alexander, would that be consistent with what you remember?
Objection leading.
Overruled.
Right?
Yes.
And so she gave you that as the specific date, whereas she gave the other expert a different date.
Objection foundation. She doesn't know what she said to the expert.
Rephrase. Sustained.
Well, you've read those notes, right?
Yes.
And you read both, were they both typewritten and as well as written out?
The portion that I'm referring to was written out.
And on those notes, did it give the same date or a different date for the same incident?
A different date.
And what other differences did you note?
The biggest difference was what she had reported on her tests that she took with the other female psychologist.
And what were those differences?
She described experiencing significantly more abuse by Mr. Alexander.
What do you mean? What is she reporting to this female psychologist that she isn't reporting to you or others?
She described being fearful of him at all times.
And did she describe that to you?
Not at all.
What else did she describe that was different?
Significantly more incidents of domestic violence, more pushing and shoving and overt forms of domestic violence.
So and with you, how many total incidents did she describe?
I mean, object which foundation, which test is she comparing this to, and which interview is Dr. DeMarte speaking of?
Overruled. That wasn't the question. You may answer the question.
There were 4 incidents that she told me about.
And when were these 4 instances that she talked to you about?
The dates?
Yes.
There was one that she said occurred in October of 2007, one in January of 2008, one in March of 2008, and one in April of 2008.
How about with regard to Richard Samuels? Did you review his report and what she reported to him about the domestic violence?
Objection foundation.
Overruled. You may answer yes or no.
Yes.
What did you review?
In his report, he again described there being a lot more domestic violence. In terms of the exact incidents, he was not as clear.
Okay, so he also reported more. Who reported more incidents? A female psychologist or Richard Samuels?
Objection foundation.
Overruled. You may answer.
They both described significantly more domestic violence.
Objection non-responsive, move to strike.
Overruled.
Ma'am, with regard to Exhibit 881, which is now in evidence, let's read it. What's the date on it?
10/25/08.
And an interview with somebody, what's the name?
Nicole.
Does Nicole have a last name?
Nicole Hassel.
And read the first line, please.
Nicole is a waitress at the Purple Plum restaurant. I spoke with her via the phone.
And first bullet point, what does she say?
Jodi said she was a goddess, smelled like a goddess, should be treated like a goddess, and looked like a goddess.
What was the second point say?
Jodi could not stay focused. She was all over the men. She would be all over the young men.
Objection, Your Honor, may we approach?
Yes, you may approach.
Ma'am, 881. Start with this again, please.
Jodi could not stay focused. She was all over the men. She would be all over the young men.
And then read the next line.
She seemed very inappropriate with men, especially with Edgar. They would do crossword puzzles and hug.
What about the next line?
She would sit and kiss and hug Edgar and most of the men.
Ma'am, in terms of the discrepancy we were talking about, whether or not a reporting of the domestic violence, whether or not there was discrepancy, correct?
Right.
I'm going to show you Exhibit 238. And this would be Exhibit 238 in terms of how many times you reported domestic violence. This is, just so we can put it in perspective, this is the to Travis family letter. You see the date there?
I do.
What's the date?
July 28th, 2008.
And it says what as to the how many times did she report to them that this happened?
That only happened on 2 occasions.
And what did she say about the second time?
The second time was on a Tuesday in early April 2008.
Okay. And then I want to talk to you about this right here. See that? What does it say?
I know it is common behavior for women in abusive relationships to protect their partner by covering for him or her and by making excuses, but I didn't see it so much like that.
In terms of that particular statement, does that tell you whether or not back in July of 2008, the defendant had any knowledge of this issue involving domestic violence?
Objection calls for speculation.
Overruled. You may answer.
It shows that she does have some knowledge of domestic violence.
So, for example, when Dr. Gettner testified about this particular issue, and he indicated that, well, in terms of some of these reports of domestic violence, they weren't reported because she had no knowledge of the domestic violence. Does that speak to that?
Objection, blatantly mischaracterized what Dr. Gettner said.
Sustained.
In terms of this quote, though, does it tell you that she had at least some knowledge of domestic violence?
Objection asked and answered and calls for speculation.
Overruled.
It shows that she has some knowledge.
And if people have knowledge of domestic violence, did you see whether or not that could conceivably be used to incorporate it in whatever responses you have seen, for example, you and the other doctors that have been associated with this case?
Objection, vouching, and again calls for speculation. Is
Sustained.
You see any trait of indication that this individual who was making this report knew or had some knowledge of domestic violence?
objection calls for speculation within her victimization.
Overruled. You may answer.
Did you?
In this letter that you just showed me,
Just overall?
that she had some knowledge of domestic
Right.
violence?
Yeah.
Yes.
And why do you say that?
Well, when I met with her and I talked with her about it, she had some clear ideas about what it meant to be an abuse victim.
In terms of, are you familiar with the allegation that Mr. Alexander may have called or may have said or used the word skinny as it applies to this defendant?
Yes.
And did you speak to Sky Hughes about this particular allegation?
Objection, Your Honor. May we approach?
Yes.
So did you talk to Sky Hughes about this comment involving the skank issue?
Yes.
And what did she tell you about it?
She told me that Miss Arias was very upset about a few things related to Mr. Alexander, and one of them being that he had referred to her as a skank. And she explained that she talked to Mr. Alexander about it. I'm talking about Sky Hughes talked to Mr. Alexander about it and found out the story that was related to that, which was, according to Miss Hughes, confirmed by Miss Arias. And the story...
How was it confirmed by Miss Arias according to Miss Hughes?
She said that she asked her and said, "Is this true?" when she reiterated the story to her, and Miss Arias said, "Yes, this is in fact true."
And what's the story then?
The story was that Miss Arias was on the phone with Mr. Alexander and had requested to speak to his roommate, who was in the room with Mr. Alexander. And he responded by saying something to the effect of, "He doesn't want to talk to you. He said that you're a skank," in a joking manner.
Is there any reason why Mr. Alexander would say that involving this particular individual?
Objection calls for speculation.
I'm sorry, your objection?
Objection calls for speculation.
Overruled. May continue.
According to Miss Hughes, his roommate was not someone who tended to cuss or make comments like that. And so Travis thought that it would be funny to say something like that that may be jarring to the roommate as a joke. And the way she described it to me was that it was, in fact, very clear that it was a joke.
And was the fact that it was a joke communicated to the defendant?
Yes, she had said that she was clear that it was a joke.
How about this issue about calling her at night? That's something that was also discussed by the Hughes letter. Did you discuss that with Ms. Hughes? Sky Hughes?
Yes.
And what did she tell you about Mr. Alexander calling the defendant at night?
Well, again, Miss Arias was very upset and had turned to the Hughes to talk to them about the things that she didn't like about her relationship with Mr. Alexander.
Objection foundation as to which conversation she's referring to.
Sustained.
You had, how many conversations did you have with Ms. Hughes?
One.
All right, and in that conversation, did she tell you about this?
Yes.
All right, tell me what she said.
Objection as to date and time of the conversation to which Ms. Hughes was referring to.
Approach, please.
Did Ms. Hughes reference when she and the defendant had this conversation about Mr. Alexander calling late at night?
It was either in December of 2006 or January of 2007.
All right, and what did she say?
She said that this was one of the things that Miss Arias was really uncomfortable about and sad about and did not like, that he was only calling her late at night, and she felt offended by it. And so again, Ms. Hughes described that she had followed up with Mr. Alexander about that to confront him about this fact that why would he only be calling her late at night, and again confirmed the story with Miss Arias Later that the reason why he was calling late at night was because she was working throughout the day and only available in the evening. And Miss Arias responded that she did in fact know that that's why he wasn't calling, but that she had wanted him to call during the day just so that she can feel like he was thinking about her.
How about Lisa Anders? Did you talk to her?
Yes.
When did you talk to her?
I spoke to her in December of 2014.
And did you talk to her about this issue involving Mr. Alexander and about any touching that may have gone on between the two of them?
Yes.
What did she tell you about that?
I talked to her about her relationship with him in general, and related to the touching, she had talked about the two of them engaging in kissing to the point that she felt kind of uncomfortable about it because of her religious beliefs. She also talked about him spanking her in public as a joke, which was something that she was not comfortable with and asked him to stop doing.
But did you also talk to her about her career choice as a teacher, and why he told her that was something that wasn't a good idea?
Objection leading.
Overruled. You may answer.
Yes, we spoke about that.
And what did she tell you?
She said that he did not agree with her career choice of being a teacher, not because it wasn't a respectable career, but because she wouldn't be financially compensated as much for all the work that she would be doing as a teacher.
And in terms of the sexual aspect, did she ever indicate that he moved beyond anything that she wanted? In other words, was he continuing on even though she told him to stop?
No, she said that any sexual activity that they had between the two of them was consensual, and they both participated in it and never felt forced in any kind of way.
Any indication that he ever physically abused her?
She said that he never did.
And in terms of the time that they were together, did she ever talk about whether or not, when she was with Mr. Alexander, whether or not the defendant would come around?
Objection, compound question.
Overruled. You may answer.
Yes.
What did she say about that?
She told me the story about a time when they were spending time together late at night, and they had seen a light that came on in the house, and Mr. Alexander went to go and investigate what that light was, and she had suspected that it was Miss Arias. When he returned, he said that it was not Miss Arias.
And later, did she find out different?
Yes, she said that shortly before he died, she was in contact with him, and he admitted to her that that was in fact Miss Arias who was there that night.
All right, ladies and gentlemen, we're going to take the evening recess at this time. Please be back tomorrow morning at 9:30. Anyone who cannot be here at 9:30, please remember the admonition. Have a nice evening. You may sit down. Counsel, anything else?
Judge, I know that we need to leave at 4, but I did speak with Perry.
I'm sorry.
I did speak with Detective Perry Smith at that time of court, and he indicated that we can't have the report done sooner than a month. What he said is that if you'll remember, we had the issue involving Bryan Neumeister, and that initially all of his work was with regard to that, and so he has things to write down with regard to that. And the process that he is going to undertake is that he's going to have a typewritten report with regard to everything that he does. And so that's the first thing that he has to do, which he hasn't done. Additionally, he then has to, with regard to some of the questions that I've asked, he then has to put that as part of the report, and then he has to go and, he used the term something about how he found, but it's how he found it out, what lines, electronic lines he went to, something to that effect. But bottom line is, he said that a month. I asked him to get it done sooner, and he said, well, I'll try. But I also indicated to him that if you wanted to know more information, that you would give him a call if I was not conveying the message appropriately, which I believe I may not be.
Well, Judge, I guess, given time, I think we do have a transcript of the interview for the court's review, but he said 1 or 2 weeks during the interview. Obviously, I think the state is endeavoring to kick this can down the road until such time as this trial is over. That is inconsistent with Skipper versus South Carolina. The other issue I think that's of significant note as it relates to the state's conduct in this case is that they have had said image since 2008. Now some issues came up as early and as far back when the motions were filed regarding the state's misconduct and issues with the computer and what they did in terms of the destruction of evidence. This happened in October. In November, these issues were raised. And now we have we interviewed Detective Smith months prior, before he testified at the hearing related to the misconduct. And that was as far back as a month ago, and he told us he was working on it. Or that was over a month ago in December. And now it's going to be another month. I would suggest to the court that the reason that Mesa Police Department does not want to complete this report, which I would be mindful of the fact that our actual expert did such a report in just a few days, that the state does not like the results of the report and is indeed trying to prevent Miss Arias from accessing exculpatory information. In that regard, for support of the assertion, I would say that Detective Brown's FDK report, which is going to be different than, his end case report, which apparently is different than what Mr. Smith is testifying to, actually contained pornographic videos. So, I don't know, perhaps Detective Smith needs to deal with that, and that's why the report isn't ready. But I would be very suspicious of the viability of any such claims, or the legitimacy, I should say, of any such claims. Because added to that, well, keep in mind Detective Smith came in here and testified at a hearing after he'd done a preliminary review and admitted that there was pornography or at least artifacts related to Mr. Alexander viewing pornography on this computer. And now, in the interview of weeks ago, he knows nothing and he doesn't have a report. So I believe the non-report is convenient for the state. It should be looked upon with suspicion of this court, and that Detective Smith's testimony should be precluded.
Well, first of all, with regard to that, I can only speak to what Detective Smith told me during the interview. I think that there's perhaps a problem can with the point. Detective Smith told him that he was only working on the 2009 hard drive, and he said that he was only using N-case, and that when you use N-case, if they doubt it, they can play it for you. That does not parse, was the term used, does not parse Mozilla Firefox. So he said, in terms of this pornography, whether it's there or not, I don't know, because N-case doesn't parse it out. Detective Brown knows about it because he used a different program that's designated for Mozilla Firefox. So I think that has to be put out there. Additionally, as he indicated to them, he only has certain items that he has done with regard to the 2009 image. He's trying to see the differences between the 2009 and 2008, and he provided them with what he called the chronology, which shows the difference. He's already provided that to them. He also talked about how their expert, when he used autopsy, was wrong. He indicated to them, look, the dates, the time that your expert indicates is wrong because there's a bug in autopsy. And there are lines that I can show you, and that's been provided to them in hard form, is my understanding. In terms of the other stuff that they're talking about, whether or not there is porn on the computer, all the porn is Mozilla Firefox. That's with regard to Detective Brown. Again, we get to the point where we argue about one detective, and they start throwing things in there about another issue, and they start talking about prosecutorial conduct, and they make what I do believe are unethical claims that are not based in facts. I have no control over the basic police department. I welcome the court calling him so you can get the information directly from him. I'm just a messenger.
Okay.
Well,
Hold on. Does the state intend to call Detective Smith at this trial?
We are.
And does he know the topics that you were going to be discussing?
He's going to talk about the problem with the time. In other words, he's going to talk about when Mr. Suderman talked about it, whether he was right or wrong. He's going to say he's wrong, and he's already told them that. He's going to talk about whether or not there were any, what the changes were from the 2008 to 2009 involving when the file was turned on. He told them about that. He also told them that he believed that there was the thing that they plug in, the filter plug in. So he told them about that. He also told them that there were certain websites that he was asked about, and he indicated that all those websites that were found in the registry per his investigation were websites that were put there by the computer. He indicated to them during the interview that there was this experiment that was done by Detective Brown. And he said he really didn't know too much about it, but what he knew was that Detective Brown told him about taking a pristine computer and making it pristine and then installing, I don't know the program, I think it was Spybot Search and Destroy, but I don't remember exactly the program. And he said that as a result of that, the items that were complained about by the defense that were somehow typed in, this is per Detective Brown, as indicated in the interview, that what Detective Brown found was that those entries in the registry were actually a result, I don't know what gave the name, but it was something to do with the programs that were installed in that manual. That was the extent that we said in the interview, and that's what I want to talk to him about the issue involving the autopsy problem. And then the changes that may have been made. Everybody knows that we talked to him about waking the computer out, that's already been talked about. And I can't remember specifically what other things he discussed, but I'm not going to talk to him about anything that Detective Brown said, because Detective Brown is going to testify. He testifies to his own things.
Is there anything you intend to ask Detective Smith that was not discussed during the interview with defense counsel?
He was not asked about waking the computer. So I'm going to talk to him about that. He didn't specifically indicate, for example, the name of the virus or antivirus masquerade that put teensec.com, but he said he has that information, as well as the other websites that we talked about. Can't remember anything else. It was about 3 or 4 areas.
Your Honor, that's not accurate, and I can certainly submit the audio tape, and I don't want to go too long today given the reasons we stopped early. But that's just incorrect about...
Why don't you bring in the interview tape or transcript tomorrow, and we'll finish discussing this since we need to be on our way today.
Okay.
All right. Thank you.
9:30 tomorrow? Is that...
9:30 tomorrow.
Okay.
If you want to talk about this issue, you should be here at 9:15. Will you have everything ready to address this issue tomorrow?
I should be able to, Your Honor. I think I can get, maybe able to get the transcript to Your Honor. Well, you might not get it till morning depending, so.
Okay. Ms. Wilmot, you'll be here at 9:15?
Sure.
Okay, so 9:15. All right, thank you.